Hello, everyone. My name is Giuseppe Martinico, and I am one of the directors of the Sant'Anna Legal Studies program, together with Giacomo Delle Donne and Filippo Fontanelli. And today I'm very glad to share this book launch devoted to the latest book by Núria, González, Campañá. Let me show you the beautiful cover of the book. And the book is titled Secession and the European Union Law, the Deferential Attitude. It's a fantastic book which has been published in the very prestigious Oxford Studies in European Law series, a series edited by Professor Paul Craig and Professor Bernard de Burca. We are very happy that Núria immediately accepted to discuss the book with us and with the stellar colleagues who accepted to serve as a discussant. Núria is currently assistant professor of constitutional law at the constitutional law department of the University of Barcelona. This book is the outcome of a doctorate at the University of Oxford. And today we're going to discuss this volume with two stellar colleagues. I said Cristina Fasone, who is a professor of comparative public law at Luis Guido Carli in Rome. Previously, she was, among other things, Max Weber Fellow at the European University Institute. Cristina is one of the most interesting voices in this debate, so I'm very happy that she kindly, as always, accepted to, join us. Thanks indeed. And the other discussant will be Francisco Javier Romero Caro, who is a senior researcher at the Institute for Comparative Federalism and of the Eurac, the European Academy of Bolzano, Bozen, and is also author of many interesting pieces in this field. The one I just mentioned, his book, El Sistema Federal de Canadá, un modello de integración. We had the pleasure to present the book in a book launch like this some years ago. So thanks indeed to Francisco Javier. And having said that, I will give the floor to Núria for her presentation. After that, we will open the discussion with Cristina's comments and with other comments from Javier. We are recording the session, so please, those who have their mic open, please make sure that you do close the mic if you are not the next speaker, of course. Having said that, Núria, I give you the floor. Thanks indeed, and ready to where you are.
Thank you very much, Professor Martinico. I have to start by saying thank you to you and also to Professor Giacomo Delle Donne for inviting me. And also I'm very grateful because my colleagues Cristina Fasone and Francisco Javier Romero Caro are also today, this afternoon, with us. I'm going to try to share a presentation with you. Let's see if I'm able to do that.
Let me see.
I think here it is.
Now, yes.
Okay.
Slowly, great. But we are. Yes, it's working. Okay. Thank you.
Okay. So as Professor Martinico was saying, this book, or the origin of this book, lies in my doctoral dissertation. And why I decided to write about this topic? Well, basically, because there has been a consolidation of pro-independence movements in Western Europe in the last decade. And it's true that usually lawyers tend to examine secession either through the lenses of public international law or constitutional law. but it was not so obvious to see secession through the lenses of European Union law. And I thought that, well, since EU has played an important, although unintended, role in making or in consolidating these pro-independence movements, I thought that we cannot argue anymore that EU is alien to secession. So that's the reason behind the book. The question that I wanted to address and to respond is the book is very simple and is the following. How should EU law respond to secessionist attempts within EU member states? And of course, you might say, well, the response of the EU is going to be based on political considerations, and that is very much true. But since the EU is also a community of law based on the rule of law, it also has to justify its position with normative arguments. And at the very start of the book, you are going to find the claims that are going to sustain the whole book. And the first one is that I already anticipate, I don't believe that the EU, contrary to what other scholars have said, I don't believe that the EU has or should have an autonomous position when it comes to secession. Second, I think that the EU is obliged to respect the national identity of the member states in the context of secession, provided, and this is a very important second part of the sentence, provided that the values of Article 2 of the treaty are not violated. And the third claim is that the characteristics of the secessionist project are going to define the response of EU law. And let me try to explain all this a bit more by exploring the content of the book. In the first chapter, what you're going to find is an exploration of some of the legal terms that sustain the whole argument. And since secession is an issue that touches upon three different legal orders that interact in a certain territory, public international law, national constitutional law, and EU law. In this first chapter, I try to explain, firstly, how we establish the binding character of international law when it comes to EU law. And this is going to be important because there are many issues that are related to secession that are going to have an impact on EU law. And then what's the relationship or how EU law relates to national constitutional provisions, why the EU is obliged to show deferential attitude. And here, of course, there is this reflection on constitutional pluralism. And then in this first chapter, you are also going to find an exploration of the term secession, how it has been defined by public international lawyers, how it has been defined and explored by constitutional lawyers. Then in the next chapter, we are going to examine to what extent public international law constrains EU law when it comes to secession, in the sense that, is there any right provided by public international law, by customary international law, that obliges the EU to have a certain position or a certain approach when it comes to secession? Some people would argue, well, public international law prohibits secession, but we know that since 2010, this is not anymore the case. Secession is not prohibited by public international law, but it's true that public international law does not confer a right to secession to regions or to subnational entities within well-established or well-functioning democracies. And this is something that the Canadian Supreme Court already established in 1998, and more recently in 2022, the UK Supreme Court also disregarded in just one paragraph the possibility of having a duty deriving from public international law when it comes to secession. So it's true that in this realm, public international law does not constrain very much EU law when it comes to secession, and it leaves EU law a lot of margin to approach secession. And what about comparative constitutional law? In this chapter, what I try to do is to explore the different responses that different national constitutional legal orders have given when faced with secessionist challenges. And of course, here the UK, the Spanish case, also the Italian and the German cases are explored, but also the US and the Canadian paradigm as depicted as the classic and the new paradigm of constitutional law when faced with secessionist challenges. And here in this chapter, you'll see that despite the responses are very different, there are some common trends. For instance, no legal order recognizes a unilateral right to secede. At most, what we might find is a certain acceptance of consensual secession in the cases of Canada and the United Kingdom. But a secession that is unilaterally carried out is considered unlawful by all legal orders. This chapter, I think it's also interesting for instance, the Spanish readers, because they will see that the Spanish very strict response to attempts to secession is shared by other legal orders, by the US legal order, by the Italian legal order, that one could argue that is even stricter than the Spanish one, and also by the German constitutional response. So a Spanish reader will see that the Spanish response is not so strange. And then we are going to find two chapters that deal specifically with European Union, treaty provisions, with European Union precedents, with European Union statements made by EU officials, and then with European Union theories. So first of all, it is very clear that there is no treaty provision dealing with the secessionist challenge of a subnational entity belonging to an EU member state. There is no case law of the European Court of Justice, so we don't have a lot of EU material to work with that. What about precedents? Well, we don't have a precedent of proper secession within an EU member state. That's true. We had the attempts of Scotland and Catalonia that are addressed in the book. But I think that there are also other cases of territorial changes, even if they cannot qualify as secession attempts, that are interesting to be reviewed because they provide some guidance. And I'm referring here to the Algeria's independence, to Greenland withdrawal from the EU, particularly to German reunification. But I also refer to the cases, the independence of the Baltic states, the dissolution of Yugoslavia, the breakup of Czechoslovakia, unilateral secession of Kosovo and Crimea, and the case of Montenegro, that is very interesting because it was the first time that the EU really stepped in an independence process. All these cases of territorial changes, again, not proper cases of secession, but cases of territorial changes, show us that the EU is willing to show flexibility and pragmatism when faced with secessionist challenges. And what about the statements of officials of the EU? Well, here we have at the very beginning, 20 years ago, Romano Prodi expressing a very clear message, a message that was later on conceived as the automatic expulsion theory, in the sense that, well, if there is if a region becomes an independent state, by the fact of its independence, it will become a third country with respect to the Union, and the treaties would no longer apply on its territory. This very harsh approach was nuanced a bit for some time by EU officials, saying, well, this is an hypothetical scenario. We will have to negotiate the scenario within the international legal order. So far, it doesn't make sense to say something else. But then when the European Commission saw, because of the Scotland case and the Catalan scenario, when the officials of the European Commission saw that this was not anymore an hypothetical scenario, then the tone changed again, and they, since 2012, started to respond every time very much following the Prodi doctrine. But again, I don't think that all these statements can really be the proof of a fully articulated policy. So we still need to reflect a bit more on how should the EU respond to that. And here we find different theories that have been developed by EU scholars. And we might find like different teams or different camps advancing very different positions. At first, we are going to find for instance, Professor Joe Weiler. He follows an approach, a very clear approach, saying that the EU should have an anti-secessionist policy because by its very nature, it is an anti-secessionist polity, the EU. He said, well, it would be hugely ironic if the prospect of membership in the Union ended up providing an incentive for political disintegration within the Union. He believes that trying to seek for separation within an EU member state is an example of non-solidarity, and it goes against the ethos of the European integration process, and it also goes against what Europe stands for. And Professor Marlene Veen has shared or has expressed very similar views in recent years. She has said that separatism is very much antithetical to European ideals. But let me also be clear, for Weiler, this is not so much a legal argument or a legal position. He says just that there is an incompatibility between the ontological assumption behind secession and the nature of the EU. But he personally does not extract a concrete legal reasoning out of his assumptions. But other scholars have done that. And in Spain, for instance, there are some constitutional scholars that have expressed that following these ontological assumptions, the EU should incorporate this anti-secessionist policy within the treaties. My problem with this approach is that, well, there are other rival views when it comes to the purposes and the missions of the European Union, and maybe the EU should remain more agnostic. Other authors have also said that what is really key is to see whether EU norms reflect or not such moral position. And for me, what is also very important, and it's also a problem that is shared by other theories that are completely different. But for me, one of the problems is that with these theories, if we turn these theories into legal norms, we are depriving EU member states from a margin of political discretion that Article 49 gives them if the EU already establishes a very clearly anti-secessionist policy. On the other spectrum, we have other scholars that have promoted a completely different theory, the so-called internal enlargement theory. Basically, what they are trying to say is that the EU is a very unique polity. It shares features or characteristics from classic international organizations, but also shares some characteristics of more federal structures. The EU is very much devoted to the promotion of democracy. In fact, democracy is one of its core values, and this is very clear in Article 2 of the Treaty of the European Union. The Union, they say, is also a community of rights to its citizens. And if the Prodi doctrine, the automatic expulsion theory, is followed, that would mean that the citizens of the newly independent state would be deprived from their former EU citizenship rights. But on the contrary, if the EU accepts an internal, or also called an automatic enlargement theory, it would guarantee the continuity of of EU law, and it would also honor the democratic principles that the Union promotes. And some Catalan scholars that have promoted this vision, they say that even if the secessionist project is carried out against the will of the parent state, against the law of that national constitution, even that, if the process is a democratic one, it should be accepted by the Union. And here, my main problem is the meaning of democracy, and the conception of democracy that is advanced with these theories, because I don't think it's compatible with the type of constitutional democracy that has been promoted in the second half of the 20th century in Europe, and the type of democracy that the Union is also promoting. Let's recall, for instance, the 2014 communication about the new EU framework to strengthen the rule of law. The European Commission, in that communication, and later on in many more documents, it describes the rule of law as one of the backbones or the backbone, of any modern constitutional democracy. So democracy cannot be detached from respect to the law. It cannot be detached to the rule of law. This conception of democracy that is advanced by the automatic or the internal enlargement theory is a very shallow conception of democracy, a conception that only takes into account the majoritarian principle, disregarding procedures and disregarding rules. And also, another problem that I do have with these theories, and this is something that has been developed very nicely by the work of Professor Constanza Margiotta, the idea that secession has to do only with democracy. And I think that this is, to say the least, misleading, because secession, that usually requires a referendum or some sort of voting, requires very much a pre-democratic choice, which is the delimitation of the demos, the delimitation of the people that is entitled to vote in that election or in that referendum. And this is not about democracy, this is about nationalism. And also, so democracy is not the only value here at play. And in this regard, I think that Professor Carlos Clos also has expressed correctly that in purely democratic terms, there is no argument to assert that the democratic right to secede of a group must prevail over the equally democratic rejection of this right expressed by a larger group. So he says why it is more democratic that only Catalans can vote instead of all Spaniards. So it's not just only about democracy. And then we come to the third group of theories that could be labeled as legalistic or neutral or agnostic. And I believe that these theories are the ones that are more accurate, because they make a very clear distinction between lawful and unlawful scenarios. Here there are different theories, some of them based on the analogy of Article 50 that establishes a duty to negotiate. But I think that the key provision to found or to ground the EU position or the EU approach to secession has to be found in Article 4, Paragraph 2 of the Treaty of the European Union. So the obligation of the EU institutions to respect the national identity of the member states that is to be found in the constitutional structures of the state. And of course here, Article 4.2 has to be seen as an expression of that constitutional pluralism that we were referring to before. The idea that the EU has to respect the hardcore constitutional issues of each member state. And this clause and this acceptance is very much a response to national constitutional courts that have sent over the years repeated signals to the EU and to the European Court of Justice, in the sense that, well, we are ready to protect the constitutional identity of our member states, even if this means not accepting primacy of the EU. So again, I know that this clause, that this provision, Article 4, Paragraph 2, is a very risky one. It's a very risky one because we know that some states have made an abusive use of this clause, And of course, this clause has to be really the last resort of the member states. And at the same time, the European Court of Justice should always have the possibility to assess the suitability of this clause. But more specifically, I'm aware that this provision could be used as a trapdoor to escape from EU obligations, and we know that it has been used as such. And this is, of course, a huge challenge to constitutional pluralism. And I think that in this regard, how to reconcile the obligation to respect the hardcore constitutional provisions of member states, those issues that make them different from other constitutional democracies around them, how to respect that, but at the same time reconcile this with the respect of EU law. And I think here the work of Luc Dimitrios, speaker, is very interesting. He sees Article 2 as the red line or the playing field of Article 4. Article 2 in the last years, it has been developed by the European Court of Justice, is now a thicker article than it used to be. Of course, it cannot impose detailed obligations upon member state as to how to organize its fundamental structures, but at least it can decide in a negative way what is not allowed. So it can draw red lines. And I think that this is the task of the European Court of Justice on a very specific case approach. It should be the one deciding whether that claim of Article 4 it's not an abusive claim. After all this debate about Article 4 and how to reconcile it with the challenges that have been posed by certain member states that have used this provision wrongly, the final chapter of the book addresses a very hypothetical scenario, but I think that it has to address it. And it's basically how the EU should behave after a successful secession within a member state. And here, of course, many responses have to deal with public international law. And in this sense, I think that the most wise and sensitive response is the one that argues that the rump state will continue with its EU membership, while the new independent state out of a secession process will have to ask for membership through Article 49, which is the lex specialis for a new membership. There is a whole debate that took place, particularly in Scotland, about to what extent Article 48 should be a better route. But I think that there are enough legal arguments to sustain that it is in fact Article 49, and that you cannot deprive member states from the possibility of deciding who they want to be or to become part of their club. And then there is also a debate or a discussion about EU citizenship and nationality. So to what extent the rump state, let's say Spain without Catalonia or Italy without the Veneto region, for instance, to what extent Italy or Spain, after that a successful secession, could withdraw the Spanish and the Italian nationality to those living in those areas? To what extent, because this could mean the deprival of EU citizenship rights, to what extent EU law can limit the behavior of the member state? And here again, despite some cases of the European Court of the European Court, despite some cases that have been used by some people saying, well, EU citizenship rights draws a line and imposes certain limits, the truth is that after reviewing this case law, the Court of Justice is only asking for proportionality when it comes to withdrawing nationality. And I think that, again, there are sound reasons to believe that in the case of secession, it's not disproportionate to withdraw the nationality to those who have voted or have been inclined to secede from that state. So, in short, and to sum up, and I know I see that I'm running out of time, let me just encapsulate the main message of the book. That is basically that following Article 4, Paragraph 2, the EU should show a differential attitude when it comes to secession and to the constitutional legal orders of the member states. The member states are allowed to have different national constitutional responses to secession, but it's true only provided such responses are in line with Article 2. So it's true that the EU does not have an autonomous position, but at the same time, it also constrains the behavior of EU member states. So thank you very much. This is basically what I wanted to share with you, and I'm looking forward to your comments on the subsequent debate.
Brilliant. Thanks indeed for this very fascinating overview of the book. You managed to cover more or less all the many interesting points raised there. So thanks so much. And now I can give the floor to Cristina. But before doing that, I want to mention that Cristina is also the author of one of the most interesting, works written on this. Indeed, she wrote a chapter on secession and the ambiguous place of regions that the real law, in which she also dealt with this question. The chapter was published in another edited volume by Carlos Croza. So that's why we immediately think of involving Cristina in this book launch. Cristina, thanks indeed. Ready when you are.
Thanks very much. Thanks for having me, for the too generous introduction. I only wrote a chapter. Here we are talking of a very rich and important monograph that I had the pleasure to read. It's really a very important scientific contribution, which really fills a gap, because it's really difficult to locate the monograph in one single discipline. It really intersects international law, EU law, comparative constitutional law, partly also legal theory and political theory, for what Núria just said, also in relation to democracy and the meaning of democracy when we speak about secession. So it's really important to have such a monographic work. We were missing something more structured, more systematic on the topic, which is crucial in my view, because the more we deepen the European integration process, the more is also clear that region, local authorities, and maybe pro-independence movements, as Núria said, will blossom or have been were blossoming for a while. Let's see what the future will look like. So I think that the reflection is important, because that we may have, even in the context of the position of Northern Ireland, and there are also parts of the book that address this case, we may see further development. And it's clear that, however, secession is somehow exceptional in well-established constitutional democracies. So that's why some of the reflection seems just hypothetical, but we have had a real test bench for some of the secessionist process. And Núria really does a great job in enriching her analysis with cases, not just Catalonia and Scotland, but also cases that are very close to the EU, in which the EU maybe had to intervene, because we had the case of Czechoslovakia or German reunification, of which she spoke. They are not precisely secession process happening in the EU, but we can gain important insights from them. And I also appreciate the book for the very balanced position Núria has. I mean, this topic is often prone to polarize positions. too generous towards secession, too restrictive towards secession, and it's also frequent that legal scholars engage with moral or ethical appraisal of secession compared to legal ground for evaluating secession. And really, Núria has a legal imprinting in her analysis, even though she's informed by other disciplines. So the argument are well developed. I will say something more. I will try to challenge Núria a little bit, if possible, because I agree. I'm very sympathetic with her approach, and with the main thesis that is in favor of the deferential approach of the EU. I fully agree. The other point that I widely shared are those dealing with the deferential but not neutral stance. And the book is very clear on this point. We cannot claim of full neutrality because it depends on the type of secession we look at. So the type of secession informs the response that the EU is expected to give. So one case is the one of lawful and consensual secession, as it could have been the one of Scotland in 2014. Another thing is the type of secession that is unilateral and that tends to become therefore unlawful as long as there's no constitution across the member states of the European Union, if I'm not wrong, that allows for secession, for even for a negotiated secession as such, now that the UK has left the European Union. Also, I'm sympathetic on the constitutional pluralistic approach, with some caveats I will say in a second. I find very, very useful the sort of typology the book builds on the type of secession. So we do have also potentially non-consensual secession that are, however, lawful, and in which case the EU should be vigilant, as Núria says, to see whether there are potential violations of Article 2, in which case, if we do have systematic threats or risk of threats, of systematic threats, the EU is allowed to intervene. But we may also have a case of non-consensual and unlawful secession, but with widely support for secession as such, in which case the situation is a little bit more blurred. And I wanted to ask Núria whether this case really referred to Catalonia potentially. It's not clear whether, in fact, the support was so wide. There are contrasting views. But to what extent these the numbers can really justify a different standpoint or position on the side of the EU. And now I come with a series of questions also for the debate. The first question relates to the choice of the legal ground Núria adopts to justify her position of deferential in favor of a deferential approach of the EU, which is the very famous clause of Article 4, paragraph 2, and the national constitutional identity limit. Núria, again, is very clear, and she also highlights the risks of using this clause, which has been controversial in the case law of some courts. So why did you take this risky path somehow, and you didn't choose another option that I could also see potentially viable? And I wanted to hear your view on that. That is to say, the reserved competencies of the member states. So under the principle of conferral of powers to the EU, we know that there are competencies that are retained by member states. And Article 5, paragraph 2 states that the competence is not conferred upon the Union in the treaties remains with the member states. So one could claim the competence on internal disaggregation of a member state, internal articulation falls within this clause. This could have been probably less challenging from a constitutional standpoint. I mean, also dealing with the case law of the many constitutional courts, but probably also less risky to some extent. So why you did not consider this clause? The second point relates to constitutional pluralism. I think constitutional pluralism is a very important conceptual device and still largely explain the EU today. However, while I'm not sympathetic at all with the views of those who think that constitutional pluralism is dangerous and as somehow trigger also justification of the action of governments or courts in rule of law backsliding countries, I also think that constitutional pluralism was fitting the Union at best in the Maastricht era or in the post-Maastricht era, because it postulates a level of mutual trust across the different constitutional jurisdictions that is probably in decline these days. And it's not just Poland and Hungary, but if you look at Italy, I mean, not sure how trusted the Italian constitutional system is today. So I see the important value of constitutional pluralism, but I see that this theory is somehow challenged a little bit from the current status quo. But then if you take constitutional pluralism on board, and also I'm going to challenge you a little bit on this point, why you seem to rule out completely that the yardstick to assess the Union position on secession cannot be at least partly EU law, in the sense that constitutional pluralism is a construction that stems from member states' constitutional system, but also interact with EU law as such. So are we sure that the EU is only allowed to stick to what the national constitutional order allows the member states to do, and not including, not just as the nuclear option, Article 2, but in the ordinary management of potentially secession processes? What do I mean by that? Of course, secession is quintessentially a constitutional disorder. You quote someone, I don't remember who said that, and I agree with that. But I think it's also a quintessentially constitutional disorder for the EU itself, not just for the internal market. If we look at the composition of the European Parliament in the previous term, there were systematically fewer members of the European Parliament compared to the number allowed, also because of the tension in within the Spanish national government in filling the vacant seats with pro-secessionist leaders. So it's not that irrelevant, the constitutional impact of internal secessionist movements also for the EU. And Article 2 is becoming more and more a yardstick to assess national constitutional development since 2018, as you also acknowledge, on effective legal remedies, judicial independence, and there is now litigation going on in front of the Court of Justice, also on Article 2 and democracy. So I would argue for more integration between the national and European yardstick, probably. And I will stop here because I think I've used all the 15 minutes I had at my disposal, but just to challenge you a little bit on something, because I fully agree otherwise with anything is written in the book. Thanks.
Thank you, Cristina. Very, very interesting comments as always. And now I give the floor to Francisco Javier. And Francisco, thanks again for being with us, and you have the floor.
Oh, thank you, Giuseppe, for the invitation. Thank you, Núria, for this wonderful book that I enjoyed very much reading, not just because of the content, but I think it's also very engaging. It's very, very, very easy to read. So it keeps you want to know more. And yeah, what can I say after the comments of Cristina and the brilliant exposition by Núria? But I'll try to make some remarks, because I must confess that I also agree with the theme that you develop in the book. But I will start with, I think it's one of the first questions that you make at the beginning of the book. That is, why is the EU so attractive to these secessionist movements? Well, simply because they want a state, and the European Union is, at least as I see it, a club of states. So states continue to be the backbone of the European Union, no matter the institutional tweaks that we want to introduce. And I mean, we have seen this just in the composition of the new European Commission. How, for example, was the Spanish president meeting the Ursula von der Leyen to negotiate, totally bypassing the European Parliament. So states are the backbone of the European Union, and I think it's very brave, and I think it's very good argument, the one of using paragraph 2 of Article 4, the national constitutional identity of the states. Also a bit risky, because this is also the provision that, as Cristina said, all these governments that are pushing for democratic backsliding, let's say, will try to use as the way out to justify their choice. So it's their constitutional identity that needs to be preserved, their new order, their new way of seeing things that needs to be implemented. But I like especially also how at the beginning of the book you develop so I like how systematic the book is, but I also like the historical approach that has at the beginning, developing different cases and the attitude that the EU had towards different cases, because I think that in some of these cases we can pinpoint some items that are important for the construction of the argument. So, for example, the case of Greenland, that was first territory, let's say, to formally leave the European Union, all the states had to agree to amending the treaties. And this is something important, because I think this is a clear legal argument to contradict this theory of internal enlargement, that they say, okay, the new states continues to be in the EU, but we need to amend the treaties in any case, because if we go to the treaties, we see that the European Union is composed of and the name of the states. So I think this is also something important. Then you mentioned the case of Cyprus, and how initially the settlement was a precondition for accession to the European Union, that in the end, because of the pressures of the Greek government and other factors, was not taken into account for Cyprus. But it's still in the discourse of the European Commission, for example, during accession talks with Georgia, and notably with Moldova. So the EU has basically told Moldova, until the issue of Transnistria is settled, we will not have a second Cyprus in the European Union. So we see these elements that you wonderfully, I think, develop in the book. And then, of course, the case of Kosovo, not just an exceptional case in secession, but also in its relation to the European Union, to the point that during the Spanish presidency of the EU Council, we saw a summit with the Balkan countries, and Kosovo was there, a country that some of the European Union countries don't recognize, notably the one that was in the rotating presidency at the time. So we have these elements that I think they are important for how you construct the argument later on. I also enjoyed the reconstruction of the different attitudes of some EU leaders towards secession. So the Prodi Barroso approach, then more ambiguous, more it's not my business, I don't really want to talk about this topic until the referendum in Scotland, and then of course the Juncker approach going back. But I think they are not mentioned in the book because of when the book was written, but it was also when Puigdemont and Comín were elected members of the European Parliament, and the first Antonio Tajani blocked the possibility of them entering the European Parliament. And then later we saw a change in the attitude of the European Union when Sassoli became president, that he basically undo what Tajani did. Eventually, it ended up in the European Court of Justice, and very recently, the court sided with the doctrine of Tajani, not with that of Sassoli. So again, the expulsion paradigm. So I think this is also important that this, and this was based actually, according to how I see it, in your argument, basically, in the national constitutional identity of the state. So it's the Spanish legislation that decides who needs to, the procedure to take the oath. This procedure was not fulfilled according to Spanish law, therefore they cannot be members of the European Parliament. So in this sense, EU law needs to adapt to national law. So I think this is important. As Cristina said, I also like how in your book you focus on the legal arguments, leaving aside the moral arguments. That I think it's a very good line that we need to draw when we talk about secession, because it's a very emotional topic, a very polarized topic. So it's good to focus only on legal terms, on legal values. This, I think, it's important. So one of the first questions I have for you is, can a secessionist process be democratic but not respect the constitutional legal order of a member state? Because it is something that you play with all these elements in the book, and one could claim that, well, to be a member state of the European Union, you need to be a democratic state. So of course, your legal order is going to be democratic. So, but could we have the opposite proposition? So this was one of the questions that I had in mind. And then also you do this, I think it's in chapter 6 of chapter 7 of the book. You talk about for example, the role of the successor state, which I think is very clear in the case you explain of Germany, Italy, Spain. But when I was reading it, it came to my mind the case of Belgium. So if we split Belgium in two, who's the successor state? Would the Walloons be the successor state? Would be the Flemish? Will be maybe in a case more similar to Czechoslovakia, with two successor states, and therefore both remaining under the EU framework? So that question, I know it's a bit provocative, came to my mind. And I like your debate on Article 48 or Article 49 of the Treaty of the European Union. I can see the reasons for Article 48, but I think I would be very skeptical because I don't think we should assume that because a territory was in the EU, if that territory is now independent, it's going to respect the Copenhagen criteria, for instance. Just because if we focus precisely only on legal grounds, probably much of the legislation that ensured those criteria being met is national legislation that's simply not there anymore. So I think this is it's a big step forward, not thinking that we should only limit to just modifying the treaties because it's simply a legal matter of inserting the name of the new country and the legal order of the European Union is being respected. I think I don't really agree with this argument. I think it can be, the case can be made, but I would be quite skeptical regarding this. And of course, yeah, we can enter then into other debates regarding this issue. About EU citizenship, I think you were very clear. This is something that, for example, was a big issue during the debate in Catalonia. And also because of some famous statements by the then president of the Spanish government. But I think that this is also important, and it goes back to my first remark that the EU, as I see this, is a club of states, and the citizenship is linked to the citizenship of the national state. If your state is no longer a member of the European Union, you no longer have EU citizenship. And finally, you mentioned something interesting that was raised during the debate when the case of Scotland, that was this possibility of the veto of a country entering the European Union. and this assumption that some had in Scotland that if secession is lawful, there is no risk of veto because this was done according to the procedures, the national procedures of the parent country. But again, I would be skeptical here. So I think that, of course, it would make accession easier. And we can connect this to what the Canadian Supreme Court said: international recognition of an independent Quebec following the procedure will be more likely. But the EU is composed of many states with very different interests. So I would be very skeptical to think that accession would be very, very easy. I think that we could find vetoes not because of national interest, the one that everybody thought, not Spain, not wanted to set an example, but we can see many different issues. And to put an example, we saw the Balloon Parliament blocking an international trade treaty of the European Union. So we can see that there can be many issues. So on this, I would like you, if you could develop a bit on the lawful and unlawful secession. How do you see this? So do you think that in legal terms, this would really make a difference? So I agree that on the political spectrum, of course, accession to the European Union, or even continuity, if you want to see the other paradigm, would be more likely. But do you think that unlawful versus unlawful secession makes a difference in regarding the use of Article 48, the use of Article 49 of the Treaty of the European Union? So I would like to know a bit more on this. And I will stop here so Giuseppe doesn't kill me for going over time. And thank you again, Núria, for this wonderful and I think very timing also.
Thanks indeed. Thanks indeed. It was indeed perfect. So now we have 31 minutes for discussion. So I would like to ask, those who want to jump in the discussion to use their virtual hand or to send a message in the chat, and I'll give the floor. I don't see now questions or comments, but in the meantime, perhaps I would like to say a couple of things in the meantime. There are no questions from the audience. I really like, among other things, the way in which you treated dealt with the so-called internal enlargement thesis. I think that you managed to debunk many of the points, that have been raised to, justify the abusive, let's say, approach, to the relevant EU law norms. And I also agree about how you framed the correct use of Article 40.2. Indeed, in my view, Article 40.2 is frequently invoked in a completely detached manner. Frequently those who invoke Article 4.2 of the Treaty of the European Union, they do so without taking into account or without mentioning on purpose, perhaps, that of course Article 4 is a broader norm, and Article 40.2 cannot be used to justify forms of non-compliance or a violation of the values of Article 2 and the violation of the fundamental rights guaranteed by Article 6. For instance, because it's paragraph 3 of Article 4 is very clear in recalling the principle of sincere cooperation. So you should always try to use the argument taking into account the principle of conferral, which is also evoked by paragraph 1 of the same provision, and the principle of loyal cooperation. I'm not sure about what you wrote concerning the impact over the relationship between national and EU citizenship, because I think that there it will very much will depend on the factual background in the case. So probably the court of justice will take into account many factors that cannot easily presented a priori. For instance, because as we know, I mean, each member state has basically different rules about how to give and how to actually withdraw a national citizenship. So it's very difficult, in my view, to foresee how the Court of Justice could solve a case like this. But I must say that I'm very much that I agree with what you wrote in the book, and I think it is really an added value to this debate. It manages to combine an evident, command of the literature, and it manages to, deal with this issue by adopting really a multi-level perspective. So I think it's a great book, and these were my comments. I don't see other comments. Perhaps Giacomo, do you want to say? Yeah, please.
Just a very brief comment. I have greatly enjoyed the presentation given by Núria, as well as the replies from Cristina and particularly Javier. Well, a point I like very much in your book is how you deal with Article 2 TU, and well, the point is you put it into the spotlight, and of course there is pretty much controversy about the meanings of values under Article 2 TU. What I like in your approach, if I have fully got it, is you highlight what is not allowed. So if you focus on the basic core of the supranational constitutional order, you mostly pinpoint what is not allowed rather than, let's say, going for a strong normative approach. And well, I think this quite convincing. So if you want to, let's say, to have a principled approach, like in the Canadian case, against a pluralist constitutional context, I think this is very sophisticated, and well, I think it might be the starting point also for further inquiry about Article 2 values. So this was my very brief comment. Thank you.
Thank you, Giacomo. I don't see other questions or comments, and so I would, if I'm not wrong, let me check.
Sorry, Giuseppe, I raised
Oh,
my
yes.
hand just for a small question.
Go ahead.
Super quick. Because I think the importance of the book is also viewed in relation to the future accession wave. In the sense that we are going to have, there are many candidate countries that are not exactly in a peaceful settlement, internally speaking, and with problems of independentist movement. So this is a very forward-looking as an approach, but do you see any of the thesis you put forward in principle applied also in the framework of the accession process? The way the EU is going to assess is clear that maybe it's less strict on the constitutional identity of those countries. So what can the book say in relation to this new accession wave and problems of secession that are there? Thanks.
Thank you, Cristina. Sorry again, I didn't see your virtual hand. I'm very sorry. And now I think Núria will have the last say, and we'll deal with this incredible series of questions. So you have more or less, 20 minutes. So I think that there is perhaps also the time for another quick round of comments, but please, Núria, ready where you are.
Okay, well, thank you all for all your comments and questions. I have to admit that some of them, I mean, it's the first time that I hear about them, and I will have to reflect more. But let me just try to. I will try to give you a response, and let me start by the end, okay, by the last questions. So, Cristina, when you say, do I see any of the theses could be useful in the next accession rounds? I think, for instance, I think it's very clear for the EU when dealing with Ukraine, for instance, that they don't want a Cyprus too. So they don't want to accept a territory or a state, a candidate with a large part of the territory in dispute, because, well, the situation cannot be compared. Of course, Cyprus doesn't have the impact in geopolitical terms that Ukraine has, but one of the things that I believe EU institutions have very, very much in mind is that they don't want to repeat that. And I also think that I'm not sure that the next accession round is going to look like the previous ones. In the sense that different types of membership, not full memberships, are going to be envisaged, I think. So we are going to have much more flexible relationships and a much more flexible structure when it comes to accept some of these candidates. Also because we have learned from the past, and it's not so easy to incorporate member states that and it's not so easy to be really sure about the enforcement of these new member states of the of EU law. So I think that EU institutions at this point are much more skeptical, and it's true that the book is very much having in mind regions that are already part of the EU, regions that are used to apply EU law, that have proven for a long time that they can be relatively reliable partners, but not so sure about the new candidates. And I think that this skepticism is very much shared widely by EU institutions, and that's why I think that they are trying to come up with more flexible approaches in order to avoid some of the problems that we have faced. One thing, because I think this has been shared by all your comments, Article 4, very risky. Why not taking another path? Look, even if I don't like this, I think that in the near future we are going to see more and more member states claiming and demanding stronger states, a stronger intergovernmental view, so less integration. And I think that one of the tools is going to be, it has already been, but it's going to continue to be Article 4. And I wanted really to have a legal reflection on Article 4. Article 4 can be used, and I think it should be used in order to try to save the project. So it's not so, I think it's not so clear to see at this moment that the union is going to survive in the next 10 or 15 years. But I think that if there is a chance to survive, is only as long as we take seriously the idea of respecting diversity and respecting member states not willing to fulfill with all the EU law provisions. And it's not my personal or my political approach, it's just accepting the reality. The reality is that there is less demand for integration, and there is a lot of, or an increasing demand among European population in many countries. As you were saying, it's not just an issue of Hungary and Poland. I think that there is a growing demand in lots of countries. I mean, I see that in Spain, in Germany, it's very clear. In France, it's also the case. I don't dare to talk about Italy in an Italian forum, but I think that there is a growing demand of intergovernmentalism and less integration. And I would like to save this project, but I think that the project has to embrace that. Either we like it or not, we have to accept that we will have to be more differential in certain aspects. And there are issues, and I having now in mind not secession, but other clearly moral and polarizing topics where EU institutions, also based on the principle of conferral, absolutely, will have to be out of the equation and will have to leave member states free hands. I'm having in mind, and I'm sorry if this is too controversial, but I'm having in mind abortion, same-sex marriage, these type of issues that are highly controversial in certain parts of Europe, and that are seen, if pushed by EU institutions, as really a completely illegitimate intrusion here. And in this regard, I think that we should be brave and sensitive and accept that this clause, on the one hand, it might be used in an abusive way, but it can also be used from the EU institutions, from the Court of Justice, in order to save the project, to say, look, yes, the respect for that, it's also in the very nature of the EU, we are going to let you decide. But it's true at the same time, I think that there are some red lines, red lines that, and here it's the connection with Professor Deledone's comment, at least red lines that have to be drawn. But these red lines cannot be as thick. And Francisco Javier was mentioning this recent decision of the Court of Justice in the Puigdemont and the Comín case. So, and here I'm going to say something that I read a few months ago, written by Miguel Maduro. He said, well, for many years, we had the constitutionalization of the fundamental rights. Then we have, since 2018, the constitutionalization of the rule of law, particularly focused on the independence of the judiciary. Next one is going to be democracy. But what I've seen is that the Court of Justice is not yet ready to do that. And I applaud this precautionary approach, because in this particular case, I don't think that that a lot of Spaniards would have understood how EU law is meddling into how the Spanish electoral law decides which are the requirements to become an elected member. So despite a previous decision related to another Catalan politician, Junqueras, that seemed that the court was ready to embrace also a clear constitutionalization of democracy following Article 2. I think that in this recent case, the court has taken the most sensitive approach, more caution, because these are not times of integration. And I think that it's very, maybe I'm too conservative, I don't know, but I think it's too risky if the union pushes too rapidly or too quickly or too hard in certain directions. So that's what I wanted to say about why taking this risky path. And there are also many other comments. Okay, the veto. That's interesting, because when the Scottish debate came up, in fact, the Spanish Minister of Foreign Affairs of that time, García Margallo, in fact said, well, not the beginning, but later on, he said Spain is not going to veto Scotland membership to the EU. It's a completely different scenario. It's a consensual secession. Is also done, or it could be done, in accordance with the British constitutional legal order. So it's a completely different scenario. It has nothing to do with Kosovo. I think that but of course the outcome of that political negotiation, because at the end of the day it's a political negotiation, is completely unpredictable. I mean, it's very difficult, and this is something that Scottish authors have also understood and admitted. I mean, the outcome of those negotiations, whether Scotland will receive a veto or not, cannot be predicted, and you never know. And 1 year or 2 years in politics is an eternity, and you cannot predict the position of the government of a member state. But in legal terms, the difference of using Article 48 and Article 49, and I think that this idea of the Copenhagen criteria, it's also and of course an excellent argument. During the presentation, I only mentioned the lex specialis argument, but of course this other argument, it's also very important. The idea that, well, the fact that you were part of the union doesn't guarantee that if becoming an independent state, you are also going to be able to fulfill with all EU law obligations. So there is this test that has to be passed. In legal terms, I don't think, I mean, I should have to reflect more on that, but at first glance, I could say, in legal terms, I don't see that the origin, the type of secession would make a difference in order to choose one path or the other. I honestly, in this regard, I'm very much clear and inclined that the only legally sound route is Article 49. Because one of the reasons, because of the Copenhagen criteria, the other one is because lex specialis tells us that, in effect, Article 49 is the one that is designed for this type of route. But it's true that in political terms, or in terms of consensus, there is not so much difference, because in both cases you are going to need a huge consensus. You're going to require unanimity. So in political terms, it's true that the difference is not very important. What about Belgium? Yeah, wow. I mean, it could be the Czechoslovak case that probably is more similar, but it could also be the case of Yugoslavia, the case of the dissolution of Yugoslavia. None of the new independent states was considered a successor. I mean, Serbia tried to do that, but it was not accepted. In any way, I think that here there is one thing that has to be taken into account. International law has certain rules when it comes to succession in international organizations, but it's also clear that it says unless that international organization has specific rules for membership. And I think this is clearly the case of the European Union. I mean, Article 49 is very important in the sense that it underlines this idea of political discretion of every member state. So the right of every member state to decide whether that new state should be accepted or not. So even if they could be considered both successors of the former Belgium, although you have here the problem of Brussels, what do you do with Brussels? But in any case, even if you accept that both states are successors and they can reassume or inherit the position of the former Belgium in many international organizations and in many international treaties, many international obligations and rights, I don't see automatically the EU membership guaranteed without the approval of the rest of the member states. Can we come up, and this is something that Weiler has also explained when talking about Scotland, can we come up with a very speedy process that finishes right after the negotiations of independence of the states concerned? Yes, very much. I mean, if there is a will, if there is political will, they will find a legal way. And I think that many of these cases of territorial changes show precisely that. The case of the German reunification is very clear in this regard. There was a very clear political will to avoid the ratification of a new treaty, so they came up with a solution. This might be the case in Belgium, but again, it's true that it's very hypothetical, and it's also very evident and very clear that we are here touching upon issues that touch upon the core of the sovereignty of the states, and in this regard, well, the national interest of each of the players is going to play an important role. You also brought up a very interesting question. Can a secessionist process be democratic and not be in accordance with the Constitution? And it's also somehow related to one of the first questions of Cristina. How should be the numbers in Catalonia in order to have a non-consensual, unlawful, but at the same time democratic? Wow. It's a tough question. I don't think we are there. We have never been there. We have never been there because there has never been a clear and overwhelming majority in favor of the secession of Catalonia, faced with a very strict legal response. I mean, in the case of Catalonia, the society has been absolutely divided. So we have not been yet there, but it could happen. It could happen, of course, and this is something that, for instance, Stefan Dion has also addressed. What if, in a sustained period of time, a clearly overwhelming majority of people is in favor of? And honestly, I think that in this scenario, there is no legal order that can stop that. There is no option. I mean, we would be in the face of a revolutionary moment, and no constitution, no legal order can stop a region that over time has a sustained, clear, white majority in favor of that. So it's a very extreme scenario that we have not seen yet, but of course it would be possible. And I think it would be like the extreme position where we could detach, and I'm not willing to accept that very often, but where we could detach the idea of democratic principle and probably rule of law. And I know that I have not addressed all the questions, but I also wanted to give some time in case someone wants to say something. Yeah, I mean, the third question that was also very interesting, the constitutional pluralism, mutual trust was there, not anymore. It's also connected to what I was trying to say. I mean, we need to embrace deferential attitude in order to save the union. And that's what I wanted to engage with this clause. Yeah.
Okay, so thank you, Núria. I think you managed to deal with a number of questions and comments. So thanks indeed. We are running out of time, so I don't think we have time for another round of questions, unless there are super quick questions. But I don't see. I don't see. No, I don't see other questions. Okay, so I don't know if you wanna say something to prop up, Núria. Also, I mean, picking some of the questions you didn't answer, or otherwise, I think we can close the session here, Núria. Let me know if you want to say something to close the meeting. Otherwise,
yeah, I did not address the EU citizenship rights issue, but I mean, it's a very long question, but honestly, you said it's very difficult to anticipate how the Court of Justice is going to react. Honestly, I think that in a case of secession, I don't see so difficulties in anticipating the Court of Justice response. I mean, I think it's very proportion. I mean, if proportion exists at some place, I think that it's very proportionate to deprive those who are willing to create a new state, to deprive them from nationality. Although, of course, in the case of Spain, that would require an amendment of our constitution, because right now that's not possible, legally speaking. But I don't see this measure as a disproportionate one. And what I have seen in the case law of the Court of Justice is that the main requirement is proportionality when applying nationality law or the withdrawal of nationality law.
Sure. No, I was just, saying that in my view, it's still very difficult to predict in advance, since very much depends on whether the person, involved in the case has another nationality or not, on whether he or she is a minority. I think there might be different components that, but mine was a very general comment. I think that your book is great, and I look forward to using this volume also in my courses. So I think it is really time to celebrate this book once again. Today we discussed secession and European Union law, the differential attitude, the fantastic book, a gem written by Núria de González de Campañá. Thanks so much to the discussant, Cristina Fasone and Francisco Javier Romero, Caro. Thanks to those who joined us online. And so thanks indeed. Then see you soon.
Thank you.